The Supreme Court has just detonated a constitutional shockwave with an 8-to-1 emergency order that dramatically reshapes the balance between state sovereignty and federal authority. This is not a technical ruling buried in legal jargon. It is a decisive shift that dismantles the federal government's long-standing ability to compel states to carry out federal enforcement priorities. At the center of the decision are preservation acts, state laws created to block local law enforcement from enforcing federal gun regulations. But the consequences stretch far beyond the Second Amendment. In a rare and overwhelming cross-ideological majority, the court has affirmed that states possess an absolute right to refuse participation in federal enforcement programs they believe violate the Constitution. This ruling establishes a new reality in which federal agencies like the ATF can no longer operate as if state police departments are extensions of their own authority, forcing them to function independently in states that decline cooperation. An 8-to-1 split on such a divisive issue signals something far bigger than partisan conflict. It reflects a hardened constitutional consensus that will reverberate through the courts for decades. What makes this order especially damaging to federal power is that it does more than reaffirm the principle of non-cooperation. It introduces a precise 3-part legal test that effectively hands every state legislature a blueprint for resisting federal overreach without legal retaliation. The court has laid out exactly how to do it. First, any such law must clearly identify which specific federal actions are considered unconstitutional, abandoning vague or sweeping declarations. Second, and most importantly, the law must prohibit state assistance without actively interfering with federal agents who are operating using their own independent resources. This distinction is the critical breakthrough. States are not required to block federal action, but they are under no obligation to support it. Third, the law must contain a severability clause to ensure the statute survives even if part of it is challenged. While some existing preservation laws may require small adjustments, the pathway to a legally fortified anti-commandeering statute is now unmistakable. The alarm inside federal agencies is unmistakable because this ruling cuts off the infrastructure that modern federal enforcement depends on. For decades, agencies such as the ATF, DEA, and FBI have relied extensively on state and local law enforcement for manpower, intelligence, and logistics. Federal investigations routinely depend on state crime databases, state forensic laboratories, and local detention facilities. This decision severs that dependency. The ATF employs roughly 2,600 agents nationwide compared to more than 800,000 state and local officers they have historically leaned on. Without state cooperation, operations that once required a handful of federal agents and minimal planning now demand large deployments and weeks of preparation. The result is a future where federal enforcement becomes uneven and regionally constrained, effectively weakened in states that refuse cooperation simply because federal agencies lack the personnel to operate everywhere simultaneously. Justice Soto stood alone in dissent, yet paradoxically, her dissent has become a strategic gift to state lawmakers. While she acknowledged that states cannot be compelled to enforce federal law, she argued that penalizing individual officers who voluntarily assist federal authorities crosses into obstruction. Legislators have taken that message seriously. Within 48 hours of the ruling, lawmakers in at least 7 states began circulating revised legislative language that removes criminal penalties for individual officers and instead strictly prohibits the use of state resources, funding, equipment, and official work hours for federal cooperation. By following Soto's own reasoning, these states are strengthening their statutes, making them more resilient, and ensuring that the Preservation Act framework becomes a permanent element of American law. As federal authority erodes, Washington is scrambling to construct costly and aggressive alternatives to maintain enforcement power. Agencies are increasingly turning toward privatized enforcement, hiring retired state officers as federal contractors to reclaim lost local expertise. Joint task forces are being expanded, using financial incentives to draw individual officers into federal service while bypassing state leadership. At the same time, federal prosecutors are pivoting away from criminal cases that depend on local infrastructure and toward civil and administrative actions that can proceed with minimal state involvement. These moves reveal a federal government fully aware that its grip is slipping. Enforcement that states once provided at no cost now requires significant financial investment. The impact of this ruling is already spreading beyond firearms policy, confirming that this moment is about far more than guns. States on the opposite end of the political spectrum are studying the same framework to determine how non-cooperation could apply to other federal priorities. If states can decline to assist with federal gun enforcement on constitutional grounds, The same rationale extends to immigration policy, environmental regulation, and drug enforcement. The result is an emerging patchwork system where federal law technically remains supreme but becomes practically unenforceable depending on state boundaries. The Supreme Court has done more than resolve a dispute. It has fundamentally recalibrated the balance of power in the United States, handing states a formidable tool to resist Washington in a way that can no longer be dismissed or ignored